So today we have a very special topic regarding Supreme Court, High Court judges and CGI. So here the topic is, can a FIR be filed against a CGI, Supreme Court or High Court judge? As we all know regarding the removal of judges, because it's a static topic, so we should also know whether a FIR can be filed, that is a criminal case can be filed against these persons or not. So the simple answer to this question is a yes. Yes, a FIR can be very easily filed. An FIR can be lodged against any sitting judge followed by an arrest. So it means FIR can be lodged followed by an arrest. Because India is a sovereign state and nobody is above the law in this country. Nobody is above the law. It's a very common thing which we know. Therefore, any person, regardless of his stature in society, is liable to be arrested if they are involved in any sort of activity not permitted by the law. So, because nobody is against the law, so they can also be arrested. Fine. Now, what is the procedure of arrest? What was the condition before 1991, now after 1991? What happened is, so here we should know a very important judgment, that is the Verrswamy judgment. So Verrswamy judgment talks about the FIR. How the FIR will be filed against Chief Justice of India, Supreme Court and High Court judges. So this is the case name you have to remember because it is a landmark case. So prosecution of the judges of the High Court and the Supreme Court were not allowed. Till 1991, the prosecution was not allowed. But after 1991, as per the landmark Verrswamy case, the top court, that is the Supreme Court, said ki yes, cases or criminal cases can be filed. Now, k.veeraswamy case was the justice of the Madras High Court who had been booked in a case of corruption. So, in a case of corruption, he was booked. Fine. Now, what are the highlights of this case? So, here we'll discuss about the highlights. It was held that no FIR could be registered against a sitting judge without the approval of the competent authority. It means directly you can't file, you have to take the approval of the competent authority. So approval is required. So here the court further stated there cannot be the registration of an FIR against the High Court judge or Chief Justice of the High Court or the Supreme Court judge without the consultation of the Honorable Chief Justice of India. It means if a case is filed against a Supreme Court judge or a High Court judge, so the first and foremost thing is consultation is required. Of whom? That is the Chief Justice of India. And in case there is an allegation against the Chief Justice of India, then the decision has to be taken by President with the procedure. It means Chief Justice, if the case is against the Chief Justice, so here the President, the decision of the President will be taken. If the case is against the Supreme Court judge or a High Court judge, then the CGI consultation is 100% required. Okay. Now coming to the next slide, here criminal cases can be filed against the judge only after the government's consultation with CGI. As we discussed now, the government has to, if the government, so for example, CBI is a government agency. Now CBI has to file a case against a Supreme Court judge or a High Court judge. So it is mandatory, it has to take the consultation with the CGI, as CGI is participatory functionary in the appointment of judges. So we all know CGI is a stakeholder in the appointment of judges. So the appointment of judges, the procedure of appointment judges is mentioned in the third judge's case. Third judge's case as per the collegium system. So we have a system called collegium system, which is a very static topic, which I have already covered in my previous video. I'll share the description, the link in the description. Okay, the collegium system where CGI plus 4 senior Supreme Court judges will form the collegium and will give the recommendation to the government. Fine. And the collegium system, the origin of collegium system is from the second judge's case. From the second judge's case, the collegium system has originated. So all these things I have already discussed in the previous Supreme Court video, which I'll share the link. Fine. Now coming to here, because it plays a part, or it's a CGI is a part of the collegium system, so here the consultation is mandatory. Now for filing a case against a CGI, if you are filing a case against CGI, the government should, it is mandatory, the government should consult any other judges of Supreme Court, and also precedent thing is required. Okay. Now, if CGI allows the FIR to be registered, then the government shall for the second time consult him on the question of granting sanction of prosecution. It means, if CGI allows, suppose CGI allows, yes, FIR can be filed against the Supreme Court judge, again the government has for the second time consult him for what? For the question of granting sanction of prosecution. So, here the consultation is done twice. Okay. Now, only a formal arrest. The Delhi Judicial Service Association versus the State of Gujarat judgment lays the procedure. So here, it lays the procedure of the guidelines, how the judges are arrested. This is the case name you have to remember. Immediate arrest shall only be a technical or formal arrest, after which it should be immediately communicated to the district and sessions judge of the district concerned and the Chief Justice of the High Court. So, immediate arrest is done, but after that a communication has to be given to whom? To the sessions and the district judge of that district concerned and the Chief Justice of the High Court. Fine. The arrested judicial officer shall not be taken to a police station without the prior orders of the district judge. So, without the prior orders of the district judge, he will not be taken to the police station, and no statements shall be recorded from him or her except in the presence of a counsel. All the statements have to be recorded in the presence of a counsel. Okay. And the next thing, he or she shall not be handcuffed. We cannot handcuff the judge. Fine. So, has Verrswamy case been practically applied? So, here also we need to know whether the Verrswamy case is practically applied or not, because it's a very old case and it's a very landmark case. So, here in 2019, for the first time in 28 years, CGI allowed an FIR against a sitting judge. So, here also we need to remember CGI for the first time allowed one case, one FIR can be filed. That too in 2019. So, it is very recent. It's very recent. Chief Justice Ranjan Gogoi had allowed the Central Bureau of Investigation, it means CBI, the Chief Justice allowed the CBI to lodge an FIR against Justice Shukla, who was accused of favoring a medical college in MBBS admission scam. So there was a scam and CGI allowed CBI or allowed CBI to lodge an FIR. Fine. So CGI Gogoi had ordered to take away his judicial functions and also recommended in a letter to Prime Minister the removal of Justice Shukla from his position. So it means Verrswamy case is in news because it was already used or practically applied, that too for the first time after 28 years. Fine. So in conclusion, the thing is, judiciary plays a very important role in our democratic country, and giving the right to equality to all further strengthens the supreme rule of law. There are also statutory provisions that exist to protect the judicial officers from offences, but this protection is not unreasonable. If any judicial officer is found guilty, then even the judicial officers can be arrested and punished. So here we should also know that Parliament has the power to remove or the removal of judges. That is a constitutional thing. But regarding arrest, it is the judiciary who has given the guidelines or the procedure as per the Verrswamy case. So ultimately what is truly depicts, it truly depicts is there is nobody above the law. So no one, even the Supreme Court judges or High Court judges or the Chief Justice of India, nobody is above the law. Fine. So that's it from this particular video. Thank you.